Hi everyone. Welcome to our webinar, Seed Freedom and Intellectual Property Rights. Thank you very much for being here. My name is Steph Hughes and I'm the Regional Coordinator in Atlantic Canada for the Bauta Family Initiative on Canadian Seed Security. So by now, many of you will be familiar with our program. It's a national program which aims to increase the quality, quantity, and diversity of seed grown ecologically and organically across Canada. This program was launched in 2013 thanks to the championship of Mrs. Bauta of the W. Garfield Weston Foundation. We owe them our very sincere thanks as we head into this, which is our fourth field season of promoting and advancing resilient regional seed systems. We're very lucky on this program to have the guidance of two national level partners, USD Canada and Seeds of Diversity Canada, so please do check them out online and see the amazing things that they're doing for seed and for seed savers across the country. This is our very first webinar of our new series called Seeing Seed from Every Angle. We developed the series out of a recognition for the many roles that seeds play in our lives, from our daily sustenance to our right livelihood to being part of our family, social, and cultural lives. So we wanted to take advantage of an opportunity this year to look at seeds through a lens that's a little bit broader than just production. We wanted to really celebrate the seed in a number of different ways. So here's a little sneak peek of what's upcoming with this year's webinar series. You can find full details on our website, seedsecurity.ca. I hope you'll be able to join us for all of them. I think it's going to be a really great series. To date, we've completed 10 webinars over the course of 2014 and 2015. All of them are recorded and available online. You can access literally hours of high-quality seed education from experts across the continent by visiting our website, seedsecurity.ca, and checking out the YouTube videos. We are also recording today's meeting, and it will be added to the list of available videos within the next few days, I hope. So we have a really terrific lineup of speakers today to help us explore the complex and sometimes polarizing topic of seed ownership. Over the next hour and a half, we'll hear from Slater of the National Farmers Union, giving us an overview of seed IPRs in Canada and recent changes to the legislation. Next, we'll hear from Julie Dawson of the University of Wisconsin-Madison on intellectual property rights challenges in the context of PPB, or participatory plant breeding. And then finally, we'll hear from Jack Kloppenberg of the Open Source Seed Initiative with his presentation, Free the Seed, Open Source Plant Genetics. We're going to get started with Slater now. Slater has been market gardening on the Slater Family Organic Farm just south of St. Mary's, Ontario for over 30 years. She is the previous Vice President of Policy with the National Farmers Union and is currently a member of the NFU's Seed and Trade Committee. On this webinar, Anne is kind of our expert on Canadian seed policy, and so we're pleased to welcome Jack and Julia from the U.S., and if you have really specific questions about Canada's frameworks, it will be important that you ask those to Anne at the end of her presentation. I heard Anne present at the 2014 EcoSign conference in Quebec, and I learned a lot from her, so I'm super pleased, Anne, that you're able to join us today. Thank you for being here, and this is your presentation, which is loaded up now.
Okay, thank you. This is new for me, presenting on a webinar, so I hope you all hear me, and I hope you don't really think I'm an expert, because I'm just going to present kind of what I know and what I understand, basically through what we've looked at, in particular through the National Farmers Union. So this is kind of as it says on the title here, a National Farmers Union perspective on an overview of seed intellectual property rights in Canada, and just to the highlight, or just to bring you up to date on some of the recent changes. So just an overview of what I'm hoping to cover, but that will depend a little bit on how quickly I get through what I'm doing. I'm not, like I say, I'm a farmer, not a professional presenter. So first, just some of the intellectual property rights we have in Canada related to seeds. And I'll just bring up the difference between PBRs, or plant breeders' rights, and patents. Canada and UPOV 91. Just to fill you in on what the farmer's privilege is, and there's always questions about heritage varieties, so I'll touch on that. If I have time, I'll look at some of the changes to the variety registration process, and just briefly mention the Farmers Seed Act that the NFU, the National Farmers Union, is always promoting. So let's just go right on to the intellectual property rights we have in Canada related to seeds. We have a Plant Breeders' Rights Act, one that was recently updated, and I'll get to that in a moment. Plant breeders, so developers of new plant varieties are able to claim ownership over the variety, and that gives PBR holders the authority over seed and other propagating material, whether that be tubers or cuttings or whatever. Plant breeders with plant breeders' rights are allowed to claim exclusive rights over varieties that are new, distinct, uniform, stable, and have a unique name. To get plant breeders' rights, you need to apply through the PBR office, which part of is under Canadian Food and Inspection Agency or CFIA, and an individual. Just in terms of food crops that have PBR protection in Canada, most of the PBR protection in food crops is in some of the larger field crops, so the crops that are grown in larger acreages, and also a lot of potatoes that have PBR protection. There's actually few vegetables that are even listed, and there are a lot of, I don't know the situation with ornamentals. That's something I'm not familiar with, although I know there's a lot of them listed on the PBR website, but how many of them actually have full protection, I'm not sure. I'll talk about the difference between patents and plant breeders' rights in the next slide, and of course, the other way that is used by seed companies to claim some intellectual property right over their seed is through the use of contracts. For example, I know in this area where I'm from, soybeans sometimes under identity preserved contracts, their farmers sign that they won't save any of the seed. The same in Ontario happens with wheat, where they sign contracts that it will be single-use wheat, or that they'll only plant the seed once. So that's just a quick overview of some of the intellectual property rights we have related to seeds in Canada. So PBRs versus patents, both are a form of intellectual property rights. Both can restrict access to or charge royalties for the use of their property. A patent is granted for an invention. PBRs apply to new varieties of plants. In Canada, and this is, I believe, different than in the U.S., in Canada, plants cannot be patented, but gene sequences can be patented. So that's how we come up with genetically modified varieties that have patent protection on them. It's the gene sequence that's patented, not the plant in itself. But of course, that gives the patent holder control over the seed, because the gene sequences are integrated into the seed. Both patents and PBRs now apply for 20 years, or PBRs for 20 years in seed, 25 years for trees and vines. And when the protected period ends, varieties may enter the public domain, or as long as they're still on the registration list. And just a lot of these sort of how things have been sorted out in Canada as to how patents apply related to seeds and plants. So whether the patents on the whole plant or on gene sequences, and decisions, sort of how things are applied as far as who is liable when patented gene sequences are found on your farm, have been sorted out through hearings before the Supreme Court. So you know, we know what the regulations are, but sometimes exactly how they play out ends up being a court decision. So the ones that apply quite a bit here on these on the related to seeds and patents are the Harvard Mouse case and the Percy Smizer case. So this is on to UPOV, and what is UPOV? In English, it's the International Union for the Protection of, or as we kind of say in the NFU, the ownership of new varieties of plants. So it's an international treaty or agreement. And what does UPOV 91 mean? First, UPOV was established in 1961, and it was revised in 1978 and again in 1991. So when we're talking about UPOV 91, that's the most recent revision. UPOV creates model plant breeders' rights laws that countries can decide to follow or work into when they put in place Plant Breeders' Rights Acts. They can use that model. Canada's first PBR Act was brought in 1990 and conformed to 1978 rules. Just over a year ago, February 27, 2015, Canada's amended PBR Act came into force, and that brought Canada under UPOV 91. So what does that mean as far as being under UPOV 91? The plant breeders' rights protection is extended to reproduction, selling, exporting, importing, stocking, and conditioning of seed. So there's more. When you get PBR protection, you have more control over seed. Before, exporting, importing, stocking, and conditioning were not part of the previous law. It's important to note that the new rules apply only to new varieties granted PBR protection after February 27, 2015. So anything that had PBR protection prior to that date remains under the 78 model. And I'll look at it more closely in the next slide, but Canada did include a farmer's privilege in our updated PBR Act. Another piece that's allowed under UPOV 91 and is included as an option that could come into play at some point under our updated PBR Act is the use of endpoint royalties. And endpoint royalties allow royalties to be charged at other than just the purchase of seed. So they can be charged on the harvested crop as opposed to the seed. So far, there's been no move to introduce endpoint royalties in Canada, but the option now exists with the updated Act. So the farmer's privilege is an optional exception that countries are allowed to include when they bring in UPOV 91. You can give farmers the privilege of conditioning or treating, stocking, and using harvested seed from a UPOV 91 protected variety on their own property. So from the NFU's perspective, we thought that we had a right to save our own seeds. That's what we've done forever as farmers. Now it's a privilege. If you behave, you can continue to have that privilege. It's also important to note that the amended Plant Breeders' Rights Act gives the cabinet the power to pass regulations that would remove classes of farmers or plant varieties or entire crop kinds from the farmer privilege, or to put other conditions on the harvested material. So I think what's important is that those changes to the sort of restrictions on the farmer's privilege, because they can be done by cabinet, that makes it much easier for a government to take action than going through a more of a regulatory public consultation process. And just this is just some of the notes that are part of the UPOV 91 explanatory notes regarding the farmer's privilege. They suggest that this exception should be aimed at crops where there was a common practice of farmers saving harvested material when the Act came in. So they specifically mentioned like small grain cereals, and they suggest that it may be considered inappropriate for fruit, ornamentals, and vegetables, and that in laying out the regulations, ensure that optimal benefits from plant variety protection are obtained for the rights holder. So it's just just for your information, some of the crops that now have varieties registered under UPOV 91 in Canada include barley, oats, soybeans, durum wheat, spring wheat, winter wheat, and various other and some of the other sorts of field crops. And you can see that some of these the rights holder is AFC is Ag Canada. Some of the rights holders are universities like Guelph and the University of Saskatchewan, and others are private companies. The Canadian Seed Trade Association has a database of field crops and forage crops and which ones have protection, and whether it's UPOV 91 or whether it's the 78. So the website's there. You may have to go to when this gets posted on the the Bauta's website. You may have to go back to that to get these websites, and just you can find more information on plant breeders' rights and how they apply to field crops from the website PBR Facts, which is very much an industry website, and so the language may be, for some people, may be seen as somewhat intimidating and threatening. So there are a number of potato varieties with PBR protection. Again, some Ag Canada, some private, and some are under the new PBR law. Some are under 78. And as I said, there's very few other vegetables in Canada with PBR protection. I do see that there are some tomatoes in the pipeline, and if you're growing tomatoes, you may be familiar with them if you've ordered seed from the States. Indigo Rose, Indigo Cherry Drops, those are new varieties that I'm seeing in catalogs from the States. And so, I think as vegetable growers, we often see patents and PVP listed in especially American seed catalogs. I think it's, it would take court cases, I think, to some extent to sort out how American laws would actually end up applying here. As far as protected varieties from the U.S. having seeds saved and used here, it would probably be somewhat different if you were trying to sell the seed, and so anyway, that's and you can find out more about vegetables and other crops at the CFIA Plant Breeders' Rights Office if you Google their website. Just quickly, heritage varieties and seed savers. Plant breeders' rights do not apply to private, non-commercial growers or older commercial varieties in the public domain. And just, a reminder that plant breeders can claim rights to varieties that are new, distinct, uniform, and stable. Therefore, they generally do not apply to heritage or heirloom varieties, since they are not new and not to native species. So that's sort of the major stuff around plant breeders' rights, and I think got to my time, so I'll just briefly mention that we advocate the NFU for a Farmers Seed Act that would give farmers the unrestricted right to save, clean, condition, store, and sell seeds. So and several other points that we have in that. Our Farmers Seed, the fundamental principles of a Farmers Seed Act are on the NFU website. And I think I'll just, I thought there was one more. So anyway, I'll just leave it at that, and I'll put that one back on in case anyone wants to see that website. So anyway, so if there's some questions, I can do my best to try and answer them.
Okay, that's really wonderful. Thank you, Anne. You covered a lot of content in a short time there. We did have some pre-submitted questions. One of them you addressed with your native species comment. So I'll go to the live questions. Genevieve wrote in to say that my understanding of UPOV is, She says, my understanding is that UPOV is mostly supposed to apply to seeds where the seed is the fruit, such as wheat. Is that not the case, and could you clarify that for her?
Well, I'm not an expert on UPOV, but that's not my understanding. I mean, it also certainly applies to other propagating ways of propagating tubers and cuttings and such. So so it's not just seed. I think that in Canada, most of the plant breeders' rights are on, sort of more seed crops like wheat and barley and such. So potatoes, which is a tuber. So that's not my So it's not my understanding.
Right. Yeah, I think that's a widely held. That was also my understanding. So I think thanks for clarifying that. One pre-submitted question was, how will IPRs impact current buyers of seeds? And I'm also especially curious about this in the context of the end-use royalties that you mentioned. Would you be able to expand a bit on that?
So on the end-use, what was the first part of the question?
Right. How will IPRs impact current buyers of seeds?
Okay. And then on the endpoint royalties. Okay, so so currently you may. I mean currently you may be paying royalties on some of the seeds when you buy seeds, because that's where the royalties usually get charged at this point, and that's the only place you could charge royalties under UPOV 78. So you may be paying royalties on seed, but that depends whether or not it's a protected variety. And like I say, there's actually not that many vegetables that are in Canada that are a protected variety. There's very few, so you may be you may be paying royalties on the seed when you purchase the seed, but that will depend whether it's a protected variety, and that will continue to be the case. Where it will depend whether or not the variety is a protected variety or not. And endpoint royalties are not currently being brought in Canada. We haven't heard any rumors that the government is about to make endpoint royalties or make them usable. I mean, it's an option, but currently they're not being brought forward as something that's going to be put in place. But that could happen. But that would allow royalties to be charged at some place other than, you could continue to charge them at the seed level, but it will but there will also be the option of paying royalties on the full crop, and it varies from country to country how endpoint royalties are enacted. In Australia, which seems to have one of the most favorable endpoint royalties for the seed companies, you pay endpoint royalties on every harvest of hay. But that's not the case in some of the other countries where they have endpoint royalties. So I think it is something to be aware of. And if we start to hear that Canada is looking at writing up their regulations regarding endpoint royalties, then we want to make sure that we're trying to push back on that.
Okay, thank you very much. One thing that I wanted to ask you as well is that there's a significant change in language, it seems, between the two versions of UPOV, 78 and 91. And you mentioned this about a farmer's right versus a farmer's privilege, and I wonder if you want to take a couple of minutes to expand on the NFU's position on kind of why that change in language is important.
Well, I think it's not necessarily a change in language that way. I think it's our interpretation that we used to have the right to save seeds, and so at one point we would have the NFU had concerns about even bringing in the first plant breeders' rights law, but we've been able to live with that one, and it does. But it didn't, even then it was, somewhat unclear as to what our options were as far as saving seed and reselling it. We certainly was pretty silent on saving seed and using it yourself. Not quite so clear on if you were selling that seed to your neighbor, but. I think industry says that the and the previous government, which brought in the UPOV 91 into Canada, industry and the previous government would say, well, the previous version of our plant breeders' rights didn't actually say anything about whether or not you could save your seed or not. So this is better because we're clearly giving you the privilege of saving your seed. Yes, so I think that each version of UPOV strengthens the rights for seed companies and makes it more difficult for farmers to have sort of control over seeds. It gives the seed companies each time it gives them more control and more rights. So. Now, instead of just having the right to sell and propagate seeds, they've got the right to import and export and condition and stock, and so I think that it's intended to give more rights to seed companies, and so that's what happens with each version, and I think it's a bit of a smokescreen to sort of suggest that we have this privilege because at one time. We didn't need a privilege to save our own seed. It was just our customary practice.
Okay, we've just got a couple of minutes left. There's a good chat happening in the chat pod. Loic has asked the question, who is fixing the cost of royalties, and is this information public?
And I will admit I don't know the. And someone else on here may. I don't know who fixes the cost of royalties. I would imagine that the plant, that the rights holder has some say over the cost of royalties, but I don't know that. Don't know that for sure. And I guess if it's public, I haven't looked it up. I would look up under the Plant Breeders' Rights Office under CFIA to see what I could find there, and hopefully it will, hopefully we'll find out somehow. It will be somewhat public if the government gets to a point of wanting to bring in endpoint royalties. But at this point, it's just royalties on the sale of seeds.
That's perfect, Anne. This is a really broad topic. Thank you so much for navigating us through some of these issues.